Well, hey, video lecture number 2 on the Supreme Court. Hoping to get this one in about 20 minutes. I think I'm going to divide these up into 5 altogether, and this is number 2. I sent you a Word document that has a note-taking chart, basically the major Supreme Court cases. Do notice that there are some that I'm discussing here, for example, McCulloch v. Maryland, that is not on that sheet. You do not need to know that for any eventual exam or final exam or whatever else. I'm just going to mention a couple of these. And again, if it's not on that sheet, you don't actually really need to know it. We'll ask you then at the end of all of this, and this would be, I guess sometime next week, whether we're back in school or not, I don't know, to have that chart completed. You can either print it, fill it out by hand if you prefer that, and then take pictures and send 4 photographs in, or you can just simply type in the information and share it that way, Google Doc, or just email the PDF, the Word document back to me. Whatever works. Again, I'm not spending a lot of time looking at these things, but at least we're not missing time. So once again, the Supreme Court, or the courts in general, they interpret the law. You can already think of some parts of the Constitution where, geez, there's got to be some interpretation. I mean, Article 1, Section 8, Clause 18, and Congress has the right to do what is necessary and proper. I mean, I think we can already determine that two people's opinions about what's necessary and what's proper may not be the same. I might implement a new policy in which you all have to give me $500 or you fail the class. Hey, I've looked at my bank account recently. I consider that to be necessary. Proper? Yeah, why not? Seems completely proper to me. I'm not a mind reader, but I suspect that you might have a different interpretation of this. Now, if you are saying it should be interpretation A and I'm saying it's B and we squabble back and forth, we don't get anywhere. Well, that's in American law and other places where the court stands in. The court says, we've read the Constitution, we've read the laws, we've heard the arguments, and this is our understanding about what's okay and what is not. Notice if you see a little V between something, you are automatically talking a court case. And for our purposes, it'll always be a Supreme Court case for the limited amount of time we have. Let's start with a couple very early ones. One, McCulloch v. Maryland. And for each of these, I'm going to lay out the case, possibly if there's an individual person worth knowing about involved, and then, what was the issue at stake and what was the decision and why. Well, what happened here is that the United States set up a Bank of the United States. It's a formal set up United States banking money. The money gets printed through this bank. Well, the Constitution does not specifically say that the United States government can set up a bank. You might assume that the leaders of the government said yes, but it's, say it together, necessary and proper. State of Maryland, southern state, did not agree. In fact, what they did is they added an extraordinary tax to every transaction. Now, does that mean that the bank wasn't allowed anymore? No, but nobody would use the bank and the bank would fail. So here's a question. Does the state have the right to tax a government agency out of business? Determination. Supreme Court, this is John Marshall's Supreme Court. He was the Chief Justice for, about 35 years in there. The bank was necessary and proper. He used that part of the Constitution, Article 1, Section 8, Clause 18, to determine that the government had the right to set this bank up and the state had no such right. Two things come out of this. One, more U.S. government power. Two, the court is determining that we are the ones that determine this, so more power for the Supreme Court. A second early case, Gibbons v. Ogden. Again, not super exciting exactly, but a man named Ogden. Maybe his first name was Zeger, maybe it wasn't. Who knows? Ogden had a monopoly. He was the only one allowed by the state of New York to take people from New York to New Jersey. Now, here's the question. People said, wait a minute, can a state stop other vehicles from doing this? What if Smith, and I suppose Gibbons might in fact be the other person, said, wait a minute, I want the right to also open up a ferry line between New York and New Jersey. Here's the decision. The Supreme Court overruled that contract. They said that it interfered with national government law because remember the Commerce Clause. The states, the government, national government has the right to regulate interstate commerce, commerce between states, because this ferry was going from New York to New Jersey. That state contract, that monopoly was not valid. And the court ruled that, in fact, yes, somebody else can open their own ferry line. What this means, and this is something that honestly till this day is still fairly important, it sort of expanded the power of the national government to take more actions when there was commerce between two different states. Now, this comes and go over the years. We've already mentioned the Heart of Atlanta Motel versus United States case from 1964. We'll come back to it in a little bit more detail. But again, the suggestion that, yes, what's written in the Constitution word for word, there's more power that the government actually has. And a case that many of you know of, this is the Dred Scott case in 1857. So Dred Scott, he was enslaved in the state of Missouri. By the way, a backstory to this. Dred Scott's owner was a man who had just inherited Dred Scott, and he didn't believe in slavery. And he certainly would have and does eventually give Dred Scott and others their freedom. But he decides, says, hey, Dred, here's the idea. I think we need to make a case out of this because here's the story. I took you from Missouri to, and I believe it was Wisconsin. Wisconsin was a state. Guys, you gotta leave. Oh. Sorry, that's daughter and friend. They're having fun, but I'm making a video of my friends. No, hey, listen to me. You need to listen. Oh my God, they're going nuts. He said, hey, look, Dred, I took you to Wisconsin. The state of Wisconsin does not allow slavery. It doesn't exist. Therefore, since you were in the state of Wisconsin and were not a slave, I think we can make a case that it's no longer valid for me to keep you as a slave. So here's the question. When Dred Scott sued for his right to freedom, does the slave have the right to do that? And it's certainly one of the least pleasant decisions in American judicial history. The Roger Taney Court, I know it looks like Taney, but it's pronounced Taney, ruled that slaves are not citizens. And the Fifth Amendment says you can't take property away from people arbitrarily, only under certain circumstances. In other words, Dred Scott, you have no more right to sue me than, say, the chair that you're sitting in or a piece of lettuce that you're eating on your sandwich. And absolutely, we have no right as a government to take anyone's slave away. Now think about where we are in American history. North and South are pulling further and further apart. There have already been some conflicts. Kansas is already in a civil war, largely over slavery. The Civil War itself is only about 4 years away. Now, what does this mean? Well, in theory, if I were to take my 23 slaves and take them to live in, let's say, Massachusetts, a state that had ended slavery nearly 100 years earlier, where there have a huge number of abolitionists, in theory, I could say, hey, these slaves are not citizens. They are my property. You can't touch them. To people in the North, especially abolitionists, slavery is now about to spread across the entire United States without limit. And I think you can make an argument that at this point, I don't know if a civil war was inevitable, but the tensions have gotten significantly higher. Moving to after the Civil War. Now, we already know that the 13th Amendment ended slavery, of course, except for people who were in jail or prison. The 14th Amendment, well, the 15th Amendment is cut ahead. You cannot deny, no state can deny an African-American man rights to vote based on his race. Although, believe me, there are other ways of doing that were done and still are to this day. The 14th Amendment, though, of those three, in its own way, it might be the most important and the most complex because it deals with more issues. So this is 1868. Has two parts to it. equal protection. This is a quote from the amendment. No state shall deny any person under its jurisdiction equal protection of the law. Due process. No state shall deprive any person of life, liberty, property without due process, without it being done the right way. Yes, you violate the tax code and you get a fine. Sure, that went through a trial. But simply taking people's liberty or their rights or their life in any way, not allowed. Notice that the original Bill of Rights applied to the national government. This is saying no state can do this. So procedural due process, there are two different types of it. One, government has to use fair procedures. There has to be a standard way of having trials, of having things done. And substantive due process, look, if a law simply says, if we don't like you, we're taking your property or limiting your liberty, that's the substance or substantive due process. What the 14th Amendment does that is so radical is that it takes most of the Bill of Rights, which we'll go over in a second very, very quickly, and applies them to the states. Here comes my little graphic that I made. It took me about 9 hours to put it on a stinking PowerPoint slide. But I was born in 1964. These things do not come easy to me. So it's called the incorporation process. Right now, I am incorporating technology into my classroom. I am taking technology and bringing it to the teaching process. So at first, the Bill of Rights only applies to the national government because that is the national law. Now, there were questions. Wait a minute, can states violate these things? And some argued yes, some argued no. But until the 14th Amendment came, it wasn't clear that any of the Bill of Rights, freedom of speech, of religion, of a fair trial, all of these things, wasn't really clear that it applied to the state governments. The 14th Amendment is this beautiful ship. And what does it do? It takes those Bill of Rights guarantees of individual freedom and liberty and applies it to each of the, today, 50 states. At the time, it was about 30 or something like that. So the 14th Amendment, with the language, says, no state shall deny equal protection or a fair process. In other words, it takes many of these Bill of Rights and applies it to the states. And very quickly now, in about 3 or 4 minutes, going to run very briefly through which of the Bill of Rights are being incorporated into through the 14th Amendment. I'll mention a handful of court cases, but we're going to come back and look at each of those individually. So it has been applied right now to the First Amendment. Freedom of speech, freedom of and from religion. The Fourth Amendment, search and seizure, i.e. you have to have a warrant. The police can't just run into your house and see if they find something. The Fifth Amendment, that you can't be forced to testify against yourself, etc. The Sixth Amendment, a right to an attorney. Now that was understood if you are held responsible for a crime, a federal crime, and being tried in a U.S. government court, national government court, all right, you have a right to an attorney. But as I've mentioned in the previous lecture, relatively few cases are tried at the national level. After the 14th Amendment, eventually it was determined it applied to the states as well. And the Eighth Amendment, cruel and unusual punishment. Yes, the states can't do anything quote unquote cruel or unusual any more so than the national government comes from. Hey, you want to talk, by the way, that language, because that's a direct quote, language that is open for interpretation. What is cruel? Well, I don't think it's remotely cruel if I have a 23-hour-long video session and I want you to take 100 pages of notes. And I don't think it's at all unusual that the test that happens the day we come back is 97% of your grade. I don't think that's cruel or unusual. I'm willing to bet that you might have a different point of view on that. And the same thing is going to be true when the courts are looking at what is cruel punishment, what is unusual. Like, that just doesn't make sense. You have not seen these amendments. The Second Amendment, that's of course the right to bear arms. Honestly, the courts have been just like standing back and almost been afraid to touch that. There have been a couple of rulings about handguns, but for the most part, they're not touching them. The Third Amendment, anybody remember what that was? That's the British soldiers can't come and stay in your house. Well, okay, that just simply hasn't been an issue. I guarantee you that if the state of Alabama were to suddenly start sending National Guard members to live in people's houses, it just wouldn't happen. So it hasn't been an issue. And the Seventh Amendment, again, not one of the more important ones, that simply said that if there is a civil trial, one that involves monetary damages in which the amount at stake is more than, woohoo, $20. You have to have a trial by jury. That's just simply been ignored. $20 may have seemed like a lot in 1789, 1791. It simply is meaningless. And of course, the Ninth and 10th Amendments, too, because those are not specific rights. Remember, the Ninth Amendment, we have a long list of things in this Constitution and in these Bill of Rights that the individuals have the right to do, to be protected from. By the way, there are other rights that we have. That's the Ninth Amendment. And the 10th Amendment is the one that kind of contradicts that necessary and proper clause. Well, if it's not in the Constitution, the power stands with the states or the people themselves. And that's not a specific right, so that has not been applied to the 14th Amendment to the states. Quick look at these ones, 1, 4, 5, 6. Freedom of speech. There are definite limits, i.e. fighting words. In other words, if I were to say to you, and I said it seriously, I am going to kill you and your family, and I mean it, that is not protected by freedom of speech. Slander, libel, basically what this means is written or spoken, open, flat-out lies. Now, I can make a mistake. I might believe that one of you is dealing drugs in your English class, and I might report this because I have information that it's happening. And really what the courts have ruled for the most part is if I thought it was legitimate information and it just wasn't, I'm probably not going to be held responsible. But if I flat out make up lies about you in order to destroy you, and it can be proven that I intentionally did it wrong, that is not protected by freedom of speech. Obscenity. Are there words or images too naughty, too wrong, that we simply can't publish them? And of course, we're talking here about the press and about media. Are there images? Are there photographs? Are there films that, in fact, one of us could produce where we say, I'm sorry, that goes beyond your individual right? We'll talk about that during the Miller v. California case a little bit later. And again, the key cases here, you see some of them mentioned. We'll get back to these. Don't worry about them now. It's just something to come back to. Also, the whole question of freedom of religion. Remember, there is the exercise clause. In other words, you have the right to practice your religion as you wish to. And now, because of the 14th Amendment, every state must allow you to do that. Of course, this gets a little bit tricky. What if my religion does not allow children to be educated? Is that my right for my religious purposes? Or, in fact, does the children and society have a right for these kids to be educated? Interesting question. Peyote is a drug. It's kind of like the, what is it they do in Peru, a lot of the native communities, the ayahuasca? Well, it's basically drug use as a religious experience. Peyote was an hallucinogen. It was illegal in the United States. There were some Native American people that say, hey, this is part of our 500,000-600,000 year heritage. We have the right to use this. There's also, remember, the Establishment Clause. The U.S. government cannot enforce religion or religious ideas upon somebody. The case that you see there has to do with the question of school prayer. If it's a public school and I am a religious teacher. Should I be able to say, students, before we begin our U.S. government lesson, I would like to read to you from the Bible, bow your heads and pray? Well, the argument would be that that is a government entity in a state, not a local government, not a national government, trying to impose religious belief. Creches are their nativity scenes. Hey, honest question. If you have at Christmas, if you have a manger scene with Jesus and Mary and all of that, isn't that a religious expression? If the city government is putting that up, aren't they imposing religion? These are all questions that will be answered and are still debated. The Fourth Amendment, unjust search and seizure. Map v. Ohio, in which the Ohio authorities went into Dollery Map's room and house without a warrant, and whoops, they found naughty stuff. They found pornography. Yes, pornography. Wait a minute. She had that. It was considered illegal. Did they have a right to be there? And New Jersey v. TLO. Kind of interesting. If you are a student, this was a 14-year-old girl, do the school authorities have the right to go into your locker to look for drugs, weapons, or some other illegal item? That was decided, the precedent was set in 1985. We'll get to all of these individually. The Fifth Amendment, self-incrimination. Hey, you've all seen this. You have the right to remain silent. Anything you say can and will be used against you in a... Well, there we go. A man named Ernesto Miranda was arrested. I believe it was armed robbery or assault. I don't recall the detail. And he said, wait a minute. They told me I had to talk to them, so I started telling them stuff, and they found stuff to convict me. I didn't know that I didn't have to speak to them. Well, the court ruled, as you probably know, that from this point, officers have to give people their rights. They have to tell them that. And if they're violated, doesn't matter how guilty they are, they should be released. The Sixth Amendment, right to an attorney. We'll get to this case as well, Gideon v. Wainwright. And the Eighth Amendment, a couple of interesting cases in Georgia. There are certainly those that argue that the state taking a life is something that shouldn't happen. That regardless of what that person did, it is a wrong, cruel, unusual thing to deprive somebody of life. Or even beyond that, are there limits to prison conditions? How much they must be fed? What, in theory, could a prison put 93 men into a small cell? Well, that would probably be considered cruel or unusual. These were a couple of death penalty cases. Actually, in 1972, the death penalty became illegal very briefly in all U.S. states for reasons not related to the cruelty of them, but something unusual about how it was being enforced. I think this is the last slide. It's going to cut off really quickly. It seems that every time I say this is the last slide, take your notes, see you soon. Reminder that you don't turn in any of the notes you've taken on any of this until the entire chart is done. There'll be a few more of these video lectures as mentioned. However, every time I give you that warning, it turns out there's one more slide. So I'm going to assume this is the last one. Talk to you soon. The end. And there's another damn slide. Okay, yes, privacy. You will notice that the term privacy does not exist in the Constitution, doesn't exist in the 14th Amendment. However, arguments started to be made that privacy, what you do in your personal life, as long as you're not harming others, as long as you're not clearly violating other people's rights to safety or security or property, are they implied by the Constitution? There are a few big cases. In the state of Connecticut, it was illegal for professional agencies to talk about birth control, contraception. A woman was arrested and sentenced to prison for having discussed birth control in a medical way with a patient. They argued that we have the right to be able to speak about these things. Roe v. Wade, a controversial one. Does the state have a right to ban abortions? The court ruled in 1973 that the state does not have that right. However, that's sort of been under attack, and we'll see. Perhaps this next court, the law may change on that. And then a couple of cases that have to do with same-sex relationships. Is a state allowed to have a law that bans consensual adult sexual relationships? Again, we're not talking about force by any means, and we're not talking about minors. But if two 35-year-old women or 42-year-old men wish to have a sexual relationship, is that their right to do it? Or does the state have a right to say, I'm sorry, this is Texas, we don't allow that? Two major cases related to that. Okay, I think that is the final slide, the final words. Let's see.